the levy of MAT on FIIs prior to the 1st of April 2015. For period subsequent to the 1st of April 2015, the Finance Bill itself had incorporated an amendment that which was clarificatory in nature, that it would not be levied. Now, for the earlier period, we had thought that at one stage that the issue could be resolved by the courts, since there appeared to be prima facie some conflicting opinions of the tribunals. Thereafter, since that was a time-consuming process, the government parallelly entered into an exercise by putting up an expert panel to go into the issue. The expert panel had submitted its report to the government some weeks ago. In the Department of Revenue and the CBDT, this report was considered at length. And there were some issues concerned with the line of reasoning in the report which had arisen. Now, instead of allowing the matter to drag on and ask the committee for in writing on those clarifications, we followed an expeditious procedure wherein a meeting was held where I was present along with the Revenue Secretary, the CBDT chairperson and the members were there, and all three members of the committee were. Justice Shah panel were also there. So we discussed that line of reasoning, and certain questions which were in the minds of the CBDT and the Department of Revenue were put before the committee. The committee took note of them and then decided to incorporate a response to them and submitted its revised draft, which is the final draft, on the 25th of August. In the last 1 week, that has been processed. And today I have accepted, on the recommendation of the CBDT and the Department of Revenue, the report of the Justice AP Shah panel dated 25th August. This report would also be made public very soon. A press release is being issued right now. Broadly, the report says that from the time of its statutory incorporation, the intention appeared to be, from the structure of the law, that the minimum alternative tax was not leviable on FIIs. The reasoning given in the 2012 order of the Advanced Ruling Authority, however, gave a contrary view. That matter is pending in the Supreme Court. How the court deals with it will be a separate issue, which I am not going into for that purpose today. And therefore, it would be necessary to make necessary changes to that effect. Now, there are two courses open. One is by issuing a clarificatory circular under the Income Tax Act. We considered that option, but we thought that may have certain grey areas. Because if post 1st April 2015 there is a law which clarifies that it is not applicable, and there is no such law prior to that period, then can the circular itself do the requisite, serve the requisite purpose? So we were of the considered opinion that the alternative course suggested by the Justice Shah panel, which is the preferred course even according to them, that a necessary amendment in the provisions of section 115JB of the Income Tax Act would be required. And we would be bringing out that amendment in the statute. Meanwhile, pending such an amendment, all the field formations will be conveyed by way of a circular that this is the decision of the government, so they'll have to hold their hands and not make pass any further orders in these matters till such time, hopefully in the winter session of Parliament or whenever there is the next session of Parliament, we'll be able to bring out such an amendment expeditiously.
So
Thank you.
What will happen to 600 crore demand raised already?
Well, all those demands will now be interpreted in accordance with the pre-1st April 2015 law.
So refund,
So,
if payment has been made, refund.
You see, now we've clarified that what applies post 1st April 2015 will also apply pre 1st April 2015. That's the recommendation of the Justice Shah panel. Well, I don't want to comment on it because there's a distinction between an FII and a foreign company per se.
Right.
So therefore, I'd let that matter proceed on its own merits.
Sir, I'm Rajesh from WSJ. What is the message that the government is trying to transmit through this particular step? Will it actually imbibe confidence among investors?
No. You see, confidence amongst investors could be a consequence of this. But having certainty and clarity in the tax law, this is one of the essential functions of the government. And therefore, since an ambiguity had arisen on account of conflicting opinions, that ambiguity is required to be resolved. Now, contrary to the impression created that we were making a law applicable retrospectively, we didn't do that. It was a result of those conflicting opinions that this has happened. And therefore, there were only two ways of resolving it. Either the courts resolved it or the legislature resolves it. Now, considering the ground realities, we appointed an expert panel, and which, since it has given a report to the government, we decided to accept that report and enforce it.
So when can the 115 JB will also be retrospective?
You see, it is now, in view of what the Justice Shah panel says, it is more clarificatory in nature because they've taken a view that this was always the position.
So the amendment is required only in the Income Tax Act, or you need to amend the Finance Act also?
No, the Finance Act will amend the Income Tax Act.
Okay, so that amendment we expect in the winter session, sir?
It can come.
So how quickly can we expect these instructions to go out with the field information?
They will go immediately. They'll go immediately, maybe tomorrow itself.
Sir, by accepting this report, what is the loss will occur to the exchequer?
देखिए, loss, if we go by the reasoning of Justice Shah panel, then they've taken a view that this was a tax not leviable. So,
सर पैनल में 3 मेंबर तो सारे मेंबर इस रिपोर्ट में सब सहमति से
हाँ, तो दो ओरिजिनल रिपोर्ट और जो बाद में हमारे मन में कुछ प्रश्न उठे थे, जो हमने उनसे सामने रखे और उन्होंने उसका स्पष्टीकरण देकर कुछ पैराग्राफ्स उसमें ऑल्टर करके उसको स्पष्ट कर दिया कि एम्बिगुटी ना रहे, तो यूनानिमस रिपोर्ट थी। और हम जो मॉडिफाइड रिपोर्ट है, क्योंकि वही रेलेवेंट है, तो इसलिए सार्वजनिक उसी को ही करेंगे। पहले वाला तो एक प्रकार से कंसल्टेशन डॉक्यूमेंट था।
So the amount which has been collected till now will be...
That's all right. There the normal procedures of the Act will apply.
So just one more question. So this is only regarding FIIs. It doesn't touch foreign companies.
This is only with what I have told you is only with regard to FIIs and FPIs.
So the other capital case which is on and on, I think we are going to give a plan 29. So that also deals with foreign codes. So will this stand of the government have any,
You see, today we have only taken a decision, and I have only accepted the report because the report itself is only on FIIs, FPIs. Thank you.
Thank you, sir.